Welcome to the latest Evershed Sutherland Legal Insights podcast. I am Angharad Hurle, a partner in our inquiries, inquests and investigations team. Today's episode of Through the Inquisitors Lens is titled, Can Inquiries and Inquests Balance Transparency with Handling Sensitive Information? And I am joined by Rory Phillips KC, barrister at 3 Verulam Buildings. Rory is an inquiry specialist with considerable experience acting as counsel to inquiries and also representing co-participants in inquiries. Rory has a broad practice and is often instructed in cases of the higher sensitivity, to include matters of national security. We will discuss the practicalities of handling confidential and sensitive material in processes that by their very nature require transparency. We hope you enjoy.
Thank you for joining me today, Rory, to discuss one of the most challenging aspects of inquiries and inquest work. So how sensitive material is handled, and we ask the question, can inquiries and inquests balance transparency with handling sensitive information? In inquiries and inquests, evidence is rarely just information. It is often personal, traumatic, and occasionally goes to the heart of national security. So how can inquiries and inquests balance the openness and transparency required of them with the very real need to protect individuals, institutions, and public confidence? Maybe if we start with the purpose of inquiries and inquests and take things from there. Both are designed to uncover the truth, learn lessons, and make recommendations for the future. Inquests operate in public and inquiries as public as possible, but there are mechanisms for closed hearings, which I'm sure we will come on to discuss. But with that openness comes responsibility, which is fundamental to fairness for participants, protection of privacy and dignity, national security, and the legitimacy of the inquiry itself. When this is all done well, the inquest or inquiry has achieved what it set out to do. But if done poorly, this can result in re-traumatising witnesses, undermining trust, and even derail the proceedings in their entirety. So maybe the first question is an obvious one, but what is actually classed as sensitive material? And I think when we start considering what sensitive material is, everybody automatically goes to medical records, personal information, and personal identifiers within documents, etc. But it does go far further than that, doesn't it?
It does. It absolutely does, Angharad. It's a huge range of material. And unless you're switched on to that from the beginning, some of it will come as an unwelcome surprise.
Yes.
So you've mentioned the personal information, which is, as you say, what we'd naturally think of. But actually, there might be, for example, commercially sensitive information, trade secrets, internal documents within organizations or companies. In inquiries, and you've already touched on this, there's likely to be distressing or graphic material, whether in the form of written documentation, photographs, or video or audio footage going to the very heart of the incident being investigated. And then, of course, familiar to lawyers, there's LPP. Because the privileged material generated within an inquest context or an inquiry will still be protected as it would be in ordinary litigation. And obviously that's an extremely important exception to the question of open disclosure. But if I may, my final category is national security or national security sensitive information. Some inquiries have at their heart this world, the national security world, the intelligence world. And there we've got to flag up a big distinction between public inquiries on the one hand and inquests on the other. In an inquest, first of all, you cannot have what we now call closed proceedings. Yep. So if there is national security material, it has to be put through a PII, public interest immunity process. And the result of that is that if the coroner upholds public interest immunity, the material disappears. It plays no part in the inquest's work. If he doesn't, then it can come into play, or maybe a version, a gist of it can come into play.
Yes.
But it's very much binary. Whereas under the Inquiries Act 2005 for public inquiries, Section 19 permits the inquiry, in effect, to take on material like that and deal with it in a closed hearing or hearings.
Yes.
And actually, that's the reason why some inquiries begin life as inquests. So, for example, the Vinyenko case, the 7/7 bombings, inquests, these began as inquests, but precisely because of this difference between inquests and inquiries, were turned into inquiries so that the inquiry could take into account the national security sensitive material.
Yeah. And I think they are all things, aren't they, that an inquiry has to be aware of and alive to right from day one, isn't it? And I think and this is one of the main parts, I think, of when an inquiry is just setting up and it's at its outset, you really have to make sure that you are considering all of these potential angles. And actually, even so far back as when you're finalising the terms of reference, you need to be considering the extent to which you're going to be able to fulfill those based on the subject matter that you're going to be considering. And particularly, I think, with the national security element that we've discussed. And every inquiry will have to grapple with the personal data element.
Yes.
And I think that's why it's obviously very important that you have those policies and procedures agreed and set up right from the outset. And even with the best will in the world, if you have, you think you've considered every potential angle, you will be tripped up at some stage during the course of the inquiry. You don't know what you don't know when you're setting these things up, do you?
I mean, that's a good general rule that I know you and I agree on, that you, with this, as with all aspects of the inquiry's work, if you're working for the inquiry team, you do as much of this thinking round.
The brainstorming at the outset, isn't it?
Brainstorming, exactly. But you have to be ready to deal with the unexpected. You have to be flexible, because once you're launched, things will surprise you. And you have to adapt.
Yeah.
And that takes us on to another very important point. I know we both share this view as well, and it's about communication.
Yes.
That if you're going to communicate and you continue making relationships with the core participants or interested parties in an inquest, you have to keep on doing that from the beginning to the very end. And then when there are these surprises, with a bit of luck, the relationships have been built, and you can take those parties with you as you have to adjust, make changes, amend your approach, depending on what the surprise is.
Exactly. And potentially revisit some of that work you've already done as well, which is always a position that nobody wants to be in, but it's a position that every inquiry finds itself in at some stage, I'm sure. And I think that also comes back to some of the proportionality points with preparing the evidence or receiving evidence, making those evidence requests in the first place as well. So those initial disclosure principles of we need the relevant material, but you have to be proportionate in what you're requesting, isn't it? And
absolutely.
That balance as well it's a very, very fine line.
Yes, I agree. And I think we'll probably return to this idea of balance throughout this. Because so often the inquest or the inquiry is balancing, for example, the need to conduct a thorough investigation on the one hand, with the need to protect these important rights, these sensitivities, the sorts of categories of information that we've already talked about. And the key to it is to keep those two things in balance, not to lose sight of the thorough investigation, which is so fundamental to the credibility of the tribunal, but also giving full weight to these important rights and sensitivities.
Yes.
But Angharad, the other thing we need to stress if we're talking about disclosure, as you've begun to, and that's a very good starting place for all of this, I think, how you actually deal with these sensitivities in practice.
Yes.
I think we need to remind people that disclosure in this context is very different to disclosure in litigation,
Indeed.
because these are both inquests and inquiries, inquisitorial processes. The clue's in the name. And therefore, it's not a question of the parties, as it were, because there aren't any parties as such,
Yes.
mutually disclosing their relevant material, deciding that for themselves, but following the rules in the CPR. Here, it's the tribunal, the coroner, or the chair of the inquiry, setting parameters for relevant material.
Yes.
And the core participants or interested parties disclosing that not to each other, but to the tribunal in the first instance.
Yeah.
And so, again, you've already touched on this, as an absolutely key early item on the procedural task list will be the protocols about disclosure. And with it, the question of redaction. In other words, how on documents, at any rate, to preserve sensitivities by redacting material. Because it's only when all of these sensitivities and other processes, like, for example, anonymity,
Yes.
have been fully taken into account, that the inquiry can be satisfied that it's safe to go to the next stage, which is disclosing, as it were, outwards from the inquiry or from the coroner to the core participants or the interested parties.
Yes. And I think that also raises another interesting question in relation to disclosure and the duties to disclose when people have this nervousness around the content of the documentation and the difference or the different powers that chairs may have, coroners have. But if I focus on the chairs in particular, and the difference between a statutory and a non-statutory inquiry as well, isn't it, Rory? Because there's often calls for a statutory inquiry on the basis that the chair would have the power to compel this evidence.
Absolutely. Well, the Inquiry Act, Section 21, Rule 9, allows for a regime where, in theory at least, the chair of a public inquiry can enforce disclosure obligations and
Yes.
indeed evidence obligations.
There's some serious consequences for failing to do so.
With serious, including criminal consequences.
Exactly. Yeah.
However, I would say that whether you're a public inquiry under the 2005 Act, i.e. a statutory inquiry, or a non-statutory inquiry, the truth is that if you're going to have an effective and efficient process, it has to rely on cooperation and not compulsion.
Yes.
For the chair of a statutory inquiry, it's, as it were, good to know that as a very last resort, he or she could take those
Yes.
enforcement steps. To be frank, though, if he or she does, it's some sort of failure. Because frankly, what ought to have happened by then, by the sort of communication, the sort of close engagement with the lawyers, with the participants that we've talked about, that they will understand why it's in their interests.
Yes.
And of course, for the non-statutory inquiry, that's what they've got. That they can't say, well, if you don't do this, we will do X or Y.
No.
It's all about persuasion, negotiation, discussion, communication. And I would say, based on experience, that can be very effective indeed.
Yes. And I think that does also come back to what we touched upon briefly earlier as well, with the policies and procedures that are published early doors with all of these inquiries to explain to the public and those who will be providing evidence how their material is going to be handled, what will eventually be made public, and how the inquiry will go about that in terms of redactions, restriction orders, that kind of thing, isn't it? And I think those protective measures really are at the heart of that, making sure we've got that cohesive approach with all the document providers, isn't it?
Absolutely, because it's all part of getting the confidence of the
Yes.
providers, so that they know that once they've handed over their material, the relevant material, which the inquiry's decided, as it were, in a proportionate judgment, is necessary for their work, they know that the inquiry will then handle it carefully, will act in accordance with its own processes,
Yeah.
and as a result of those processes and no doubt further discussion, they'll reach a place, we all hope, where what emerges in terms of onward disclosure is something with which, as it were, both sides in relation to any material are content.
Yes. Yeah. And I think there are various measures there, aren't there? I think the obvious one that everybody's familiar with really is redaction.
Yes.
And that is simply to block out that information that is highly sensitive and should not be made public. And that usually complies with like the data protection obligations and some of the fundamental issues, isn't it? But then you can go further because there may be certain sensitivities that the inquiry is unaware of, but as individuals or organisations thinking, well, actually, we cannot allow that information to be made public. So then you have some more that are like anonymity orders for individuals, for example.
Yes.
I know you've got an awful lot of experience of dealing with these, Rory.
Yes.
So what are some of the really key ones that you found have been helpful over the years?
Yes. I mean, just to take anonymity, which is just one of a range of measures that you can take, as it were, protective measures that the chair can take under the Act. Anonymity itself, we could have an entire and separate podcast, Angharad, what a thought, on that topic if we really wanted to. But by way of as it were, advice to anybody who finds himself or herself on a team where in an inquiry where anonymity is important, perhaps in a sensitive area, it can be the most enormously time-consuming stream of work, which has to go alongside all those other processes that you've been describing, but which will be, for some core participants or material providers, absolutely fundamental to their continuing cooperation. And the application of the law on anonymity, if things can't be discussed and agreed, can be a very time-consuming process involving risk assessments and looking at the Article 2 cases, Article 3 cases, etc. But that's not the only thing that chairs can do if we're talking about this. And again, no time for detail now, but we've talked already about closed hearings.
Yes.
But even within open hearings, as in criminal cases, or indeed civil cases, there are other measures that chairs of inquiries can take. For example, screening, giving evidence in a protected way, so that, for example, perhaps only the core participants and their lawyers are able to see the witness, giving evidence remotely from another location with further measures to make sure that there's no ability to identify the person giving the evidence. The exclusion of some parties, the public, the media, possibly, from parts of hearings under restriction orders, which we've already mentioned. And those measures together give a chair, as it were, a range of possibilities, many of which will be completely unnecessary in most days of
Yes.
evidence, in most inquiries. But
Yeah.
just to note, they're there if needed.
Yeah, that flexibility in knowing that they are there. And quite often, I think that is very reassuring for witnesses, particularly vulnerable witnesses who are concerned about whether they'll be called to provide evidence publicly or, as you say, screened or another location. Just knowing that that flexibility is available to them
Yes.
and actually having that explained to them again comes back to this confidence and communication point, doesn't it? That actually communicating all these different options can really make a difference. And I think just the general practicalities as well of all of this is also a very important thing to consider because from the moment that sensitive material arrives in the inquiry's hands, how it is handled matters.
Yes.
And that can be come back to some of the secure transfer protocols and maybe a specific protocol in relation to that, and down to how that information is actually transferred, whether it is electronically transferred, if it's hard copy, who can receive it, who can see it. Do there need to be any additional restrictions, even within the inquiry team, to actually limit who can see that information even further within that, isn't it? So, there are
Yes.
so many things to actually consider.
There are, and they're really important, not least just to take an example. There are some material providers in inquiries, for example, the intelligence agencies, who, as a matter of statute, are simply not permitted
No.
to let their material out of their own very, very tight control without very serious protocols, guarantees, processes being put in place so that they can themselves be satisfied that to allow disclosure to the third party, in this case, the inquiry, for example, would not put them in breach of
Yes.
their own statutory regime.
Yes.
So again, the inquiry will have to engage with them, seek to persuade, seek to obtain their confidence. That's just the reality of the
Yes.
situation.
And I
Communication.
and I think with some of that, the way they stores, where they've got secured room, restricted access, for additional encryption that only certain team members have the passwords for. And again, it just comes back to these clear rules as well, doesn't
Yes,
it? Like the clear rules, not only for the outside world as to what's going to happen, but even internally within the inquiry team to say, actually, these are the only people that can see this information.
yes,
And having an even smaller team, as it were, within the
yes.
inquiry to actually deal with it. But then I suppose coming back to the question I asked right at the outset, that how can you get that balance though between transparency and protection?
Well, that's absolutely key. And we must be careful when we're talking about, negotiating with the document owners, etc. One has to be careful to remember that in most inquiries, it's not just pulling in one direction. There are at least two pulls, and you
Exactly.
put your finger on it there. And the inquiry needs for its credibility to be public as much as possible. It's in the Act. It's in Section 18.
Yes.
And in most inquiries of the kind we're talking about, there will be at least one core participant whose position, and
Yes.
often the families, the survivors, however you want to put it, whose position will be that everything should be in open, or at least that as much as reasonably possible can be. So
Yes.
the inquiry will find itself in something of a tug of war, and it has to, getting back to my point about balance, it has to strike the balance
Yes.
in a way that protects what needs to be protected on the one hand, but satisfies the other parties, as it were, that it's done what it can to make as much of it public as possible, frankly, not just for their benefit, but for on this key question of public confidence
The
in the
public
process
confidence,
itself.
isn't it? Yes, the public confidence against legitimate secrecy or privacy of information, isn't it?
Yes.
And when an inquiry chair is considering all this with the legal advice that it receives, or he or she receives, you know, they have to have on the one hand, yes, they want this information, they need this evidence to be able to fulfill the terms of reference, but they can't overpromise either to say, well, actually, we'll protect everything, because over disclosure or over redaction, either way you look at it, it has its risks, doesn't it? So it does really come back to this really fine balance.
Yes. And again, Angharad, just being really clear, for example, when core participants or others produce material, which is then disclosed in the first instance to the other core participants,
Yes.
the protocols have to make it clear that there will be at least some of that material, which either in the form of witness evidence or just as documentation referred to in hearings, will be put on the website.
Yes.
And what you cannot afford is for somebody to think, oh, well, I'm producing this information, but it's really only going to the inquiry, and that'll be the end of it.
Yes.
Because it actually won't or may not be. And you've got to get that out there and understood early.
Yes, and I think that is a very important message when representing core participants, or any document providers. Actually, they haven't necessarily got to be a core participant. Saying, actually, anything you provide the inquiry, you need to be providing on the basis it may be made public.
Absolutely.
Subject to all the restrictions, etc., we've discussed,
yes.
But there is always a possibility, and a high possibility, that that will actually be made public. And I think, again, this comes back to the communication point, doesn't it, Rory? That having those conversations, those grown-up conversations right from the outset, to say, this is the potential worst case scenario to an extent, that all of these documents will be made public.
Yes.
And I think that also ties in then with media relations as well, and managing the public expectation as well from the inquiry's perspective.
And it's I think you and I have agreed on this before, Angharad, but it's an aspect of an inquest work or an inquiry's work which lawyers are not necessarily good at or familiar with or happy about, but it is the reality. If you're going to conduct a public investigation into a matter of public concern, which is, what a public inquiry is, then you have to bear in mind the reporting, the legitimate reporting, which will undoubtedly occur, and be ready for it, and be ready to deal with that. Because if it's not truly public, and the most obvious way of getting the public aware of it, apart from your own website, is via the media, then in a way you're not doing your job.
No.
But that brings with it risks, leaks, matters of that kind. And again, you just have to be ready for all that. You will have processes and procedures, but in the end, they tend to be the sort of unwelcome surprise that we were talking about, which happens in the life of any inquiry.
It does. And I think those unwelcome surprises can happen in many ways, can't they? But I think we've all been in a public hearing when a witness has said something they shouldn't have said because there is a restriction order, or there is something in place or mechanism in place that information isn't supposed to be in the public. But that's why we also see, as another protective measure, often chairs will say there needs to be a delay on the broadcasting. So whilst most inquiries these days have a live stream, that is usually subject to at least a few seconds delay, so that should that happen, that live feed can be cut immediately. The transcript is usually redacted, and that information is kept within the hearing room. But still, there may be media within the hearing room, so having that media team there to support and say, there is a restriction order, and the chair will undoubtedly remind everybody in the room about that. But it's, again, the communication and reminding people
Yes.
of their duties, because they aren't only the duties of the inquiry.
No, that's absolutely right. But there's another point, isn't there, which we might bring up here, which we flagged at the very beginning, which we haven't come back to. And again, it's a question of thinking ahead and taking the participants with you. And this is to do with material which is going to be distressing or intensely distressing for relatives, say, for survivors, for those closely involved in the incident, whatever went wrong,
Yes.
so that you maintain good relations with them, good cooperation levels with them. And the way to do that, because inquiries can't tiptoe around this material.
No.
If it's at the heart of their work, they're obliged to follow the evidence where it leads. What you have to do, though, is you have to find a way of ensuring, again, proportionality, that what you're doing is transparent, rigorous enough.
Yes.
But where possible, you are also curbing or limiting the effect of what happens on those who are going to be most closely affected. So that might mean simply a series of warnings at the beginning of hearings. It will probably mean in most inquiries nowadays having trauma counsellors available and present and identified in the hearing room. There may be other ways of slightly ameliorating the impact of evidence of this kind, working with the families and their representatives. But it's not, I'm not advising anybody to avoid evidence or material of that kind. I'm simply saying you need to think about it and think about it early and have a plan for dealing with what will for some people be a process which they may have fought for. They may desperately want the inquiry, but at the same time, it's actually a form of re-traumatizing.
Yes, and I think this is an area that's increasingly recognised as essential, actually, because unfortunately it has been done badly in the past.
Yes.
And I think making sure that you are having those trauma-informed discussions, essentially, isn't it, from the outset? And there is another podcast in this series actually that deals specifically with that. But you know, this is a particular element that isn't a strictly legal one, is it? This is being a human being, a human one, and actually being really thoughtful about the decisions and how you approach things. And again, communicating with those who are going to be mostly affected by this and discussing it with them, consulting with them and saying, well, actually, how can we manage this material in the most appropriate way? Because it is fundamental to the terms of reference and it is of vital importance. This evidence is presented and made public, but just doing that, saying it's a trauma-informed and very sensitive way, I don't think can be underestimated.
No. And I also agree, as you know, Angharad, that many of these aspects of dealing with sensitive material are as much about human interaction and being a sensitive, sentient human being as they are about being a lawyer. That might make me very unpopular with lawyers, but it's nonetheless true. You can be a great lawyer, but if you don't have that level of human sympathy, then you may struggle to be a great inquiry lawyer. Anyway, that's a big topic. But it is also what you've put your finger on there, an example of how, when not properly handled, things in this area can go very badly. So the hearing or the calling of evidence that takes place in relation to this upsetting graphic material can be devastating to the trust that may have been built up to that point between the inquiry and the families or survivors and their representatives. But there are a number of others. And we've been trying to highlight how best to do things, but obviously the other sides have all of the downside consequences that you'd expect. For example, if you go over the top with your redactions, if you get so concerned about the protection of sensitive information that documents are produced that are mostly black and contain virtually
completely undermines things, doesn't it?
Completely undermines people's confidence in your process and in the idea of getting things out into the open, the public investigation of a serious incident. And that is, when compared with the other side of it, which is missing something in redaction, which can, of course, in the worst case, be absolutely devastating. Let's talk about anonymity there, for example. If there is a true and valid claim for anonymity based on risk to life, for example, then for a document to leave the inquiry and go outside the inquiry, never mind to be made public, can be very dangerous and damaging indeed. And it's hard to recover from that. And the same applies to the, as it were, the downside of what you were talking about in terms of the inquiry's internal processes. If the inquiry takes a hold of highly sensitive material and mishandles it, then it will lose, quite apart from any other consequences, it will lose the confidence of the providers of that sensitive material, and it will be very hard to recover.
Yeah, it certainly will. So then, taking all of that together, Rory, if you needed to really pinpoint what you think are the vital and key parts of handling sensitive information in an inquiry, where would you start?
Well, I think in a way, we've already flagged it, haven't we? Because I think the answer is you start early.
Yeah.
You try and think your way round where these sensitive, these sort of sensitivities are likely to come up in the context of the particular investigation. You get your processes and procedures out there as quickly as you can in the light of that analysis. And before, during, and all the way through, you communicate. You communicate not just, as you've said, with the core participants, but with the providers of the material. And of course, also whether they're providing material or not, and always with the families or the survivors, the people who are at the heart of the investigation.
Yes. So I think right at that outset, you are considering how the end is going to look, aren't you? In a sense,
yes.
You know, you're planning for publication from day one, and how you're going to be able to fulfill your terms of reference. And the things we've discussed, you know, are key throughout. So the making sure that you have the clear policies and procedures that everybody's aware of. That's not only the public facing ones, I think, and that's the important bit. It's also the internal. It's making sure that all your staff are aware and the teams are all aware of how things are supposed to be handled and the most appropriate way of dealing with things. So getting that training right from the outset and refreshing that throughout the course of the inquiry as well. And I think that's another thing we haven't really touched upon is the duration of these inquiries can be quite long and things change, don't they? So it is really important to actually be agile with the way you're thinking about your approach to these as well. And constantly revisiting those policies and procedures and thinking about any decisions that are made now how they could possibly affect decisions that were made a year or two ago.
Yes, flexibility,
Yes.
adaptability, and a willingness to change, including, as you say, to go back over earlier decisions and say, well, actually, thinking about it now we know X or Y, which we didn't know.
Yes.
We need to tweak, amend, change, whatever. Yes,
Yeah.
I agree.
And at the core, I think it's always just considering how those decisions are then going to be perceived by the public
Yes.
as well, isn't it, throughout? Yeah. Okay, well, I think that covers the main areas that we're able to cover today, Rory. I know both of us can and could easily speak about this for a number of hours. But handling sensitive material well is one of the quiet foundations of a successful inquiry or inquest, I think, is what we've both agree on today. And when it's done properly, it protects the individuals, it can support fairness and really reinforce the public confidence in the process that's being undertaken. But when it isn't, the consequences can certainly be long lasting. So thank you very much for your time today, Rory.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.